is docket 26-3500 FH. People of the state of Michigan versus Robert Joseph Almazan.
Yes, ma'am.
Thank you. Counsel, your appearances for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Assistant Public Defender Sarah Donnelly on behalf of the Attorney of Record Jonathan Foreman for the defendant Robert Almazan, who stands to my right.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Ms. Donnelly, will Mr. Foreman be here for the sentencing then?
Your Honor, it'll either be, I intend to be here for the sentencing because I'm here for the plea, but if in the event that I can't be able, I will find coverage for it, but I intend to be here.
Okay, I just was gonna ask, is it all right if you have two separate attorneys, or would you like Ms. Donnelly to be here for the sentencing as well?
Well, I'm dealing with Jonathan Foreman, but she's here today, so.
So are you okay dealing with both of them?
Yeah.
Okay, we just need to make a record of that.
Yes, sir.
All right, thank you. And sir, do you still reside on Doreen Drive?
Yes, sir.
And have you taken any medication yesterday or today?
Just I
don't need to know what, I just,
No.
so it's nothing that would
Yes,
affect
yes.
your ability to understand your attorney or the court?
No.
And is there medication you're supposed to be on that you're not on? Any sign of fever, COVID, or other illness?
No, ma'am.
I understand there's going to be a plea today,
Yes.
and you made that decision after talking with your attorney?
Yes.
And no one forced, threatened, or coerced you into making this decision?
No, ma'am.
Other than the plea agreement, no one promised you anything?
No.
And you've been satisfied with the representation of both Mr. Foreman and Ms. Donnelly?
Yes, I am.
All right, thank you. And what you're pleading to, were you on probation, parole, or bond conditions at the time?
I believe so, yes.
Another file, or are you talking about pretrial services?
I'm not exactly sure, Your Honor. It is a very old file. This happened in 2019, I believe. I don't have any record though that he had done a probation violation in our county.
Okay,
I don't see one in our county either.
okay,
Your Honor.
why is this so old?
There was a period that he was in bench warrant status for several years.
Okay, all right, just making sure we didn't drop the ball somewhere. Okay, and what is the plea offer?
Yes, Your Honor. The defendant will be pleading to count 1, operating while intoxicated, third offense notice, and count 3, felon in possession of a firearm. Upon successful plea and sentencing, count 2, carrying a concealed weapon, count 4 and 5, felony firearm, count 6, carrying concealed while under the influence, count 7, driving while license suspended, and habitual second will be dismissed. There is also an agreement to county cap at the time of sentencing, and any restitution to be determined at the time of sentencing.
Full, fair, accurate, and complete?
Yes,
Full, fair, accurate, and complete?
Yes.
And counsel, you're waiving reading the habitual second along with counts 2, 4, 5, 6, and 7?
yes.
As you're reading the felony information, counts 1 and 3.
Yes, Your Honor. People of the state of Michigan versus Robert Joseph Almazan. State of Michigan, County of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 1, operating while intoxicated/impaired, third or subsequent offense notice. On or about November 8th, 2019, at Lake Lansing Road and Harrison Road, City of East Lansing, Ingham County, State of Michigan, the defendant did operate a vehicle upon a highway, Lake Lansing Highway, while having an alcohol content of 0.08 grams or more per 100 milliliters of blood, contrary to statute. While that is typically a misdemeanor, there is a third or subsequent offense notice, which makes it a felony. Take notice that the defendant was previously convicted of operating while intoxicated on or about July 23rd, 2013 in the 55th District Court, and of operating with a high VAC on or about January 4th of 2012 in the 56th District Court. Therefore, upon conviction, the defendant will be subject to an enhanced sentence under statute and vehicle forfeiture per statute. This is a felony that has punishment up to a maximum of $500 to $5,000 and either 1 to 5 years or probation with 30 days to 1 year in jail, at least 48 hours to be served consecutively, and 60 to 180 days community service, rehabilitative programs per statute, cost of prosecution, reimburse government for emergency response and expenses for prosecuting defendant, see statute, mandatory vehicle mobilization for not less than 1 year or more than 3 years, see statute, unless the vehicle is ordered forfeited under MCL 257.625N. A term of imprisonment imposed must not be suspended unless the defendant agrees to participate in a specialty court program and successfully completes the program. Count 3, weapons, firearms, possession by felon. On or about November 8th, 2019, at Lake Lansing Road and Harrison Road, City of East Lansing, Ingham County, State of Michigan, the defendant did possess and transport a firearm when ineligible to do so because he or she had been convicted of a possession of controlled substances, delivery and manufacturing, cocaine, heroin, or another narcotic less than 50 grams, a specified felony, and the requirements for regaining eligibility had not yet been met, contrary to statute. This is a felony that is punishable up to a maximum of 5 years and or $5,000 with mandatory forfeiture of the weapon or device per statute. Court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes, ma'am.
So you understand operating while intoxicated, third offense is a felony punishable by 5 years. There's the enhancement because the first one's 93 days, the second one is 1 year, and it's a third or subsequent offense, so it now is the 5 years. Do you understand that?
Yes,
And also the count 3 weapons, firearms possession by a felon is punishable by 5 years, and there will be mandatory forfeiture today of all contraband, including any weapons and ammunition. Do you understand all of that?
yes,
You also can be responsible for the cost of arrest and prosecution, et cetera. And we'll determine that at sentencing. I don't know if there was an accident or if there's anything else that's due. So we'll talk about restitution and cost recovery at the time of sentencing. Do you understand that?
yes, ma'am.
And what I just told you about restitution and also forfeiture goes to all counts, not just the pledged 2 counts. Do you understand that as well?
Yes.
All right. And what's the status of that vehicle? I know it's been some time, but,
I still own it.
okay. So under the statute, it will have to be immobilized or sold.
Yeah, it's in the shop right now, so it's in the dealership getting fixed, so.
Okay, well, per statute, we'll have to deal with that. All right, thank you. It looks like you signed the advice of rights form. Did you read it before you signed it?
Yes,
And did you understand what you read?
yes.
If you had any questions about your rights, was your attorney able to answer those?
No,
You didn't have any questions?
no, I don't. Oh, yeah, yes.
So the way I asked it and you answered it, it would seem like she didn't answer your questions.
No,
but
she didn't.
She answered your,
Misunderstood.
yeah,
I misunderstood, I'm sorry.
no, it's not your fault. It's frequent that happens, but you didn't have any questions, but if you had any questions about anything, she's answered them so far. Is that correct?
Yes.
Do you have any questions about your rights at this court?
No.
Sir, as to count 1, operating while intoxicated, impaired, third or subsequent offense, how do you plead?
Guilty,
As to count 3, weapons, firearms, possession by felon, how do you plead?
guilty,
And sir, do you understand that by pleading, you're giving up your automatic right of appeal? If you choose to appeal, you first have to ask permission of the Court of Appeals.
yes,
You're also giving up your presumption of innocence, your ability to cross-examine witnesses and evidence, your ability to hold the people to their burden of beyond a reasonable doubt, the ability to provide a defense, et cetera. You understand all of that?
yes.
All right. And has anyone told you what I will do at sentencing? Has anyone told you what I will do at sentencing?
No,
Because I don't know. I don't know much about your case, but I will decide when I'm fully informed. Do you understand that?
yes, ma'am.
There's also an agreement that there be a county cap. at the time of sentencing, which means no more jail. It could be 0 to 365 days, but if I sentenced you to prison, I would allow you to withdraw your plea, and this matter would again go to the pretrial stage. Do you understand that?
Yes, ma'am.
All right, thank you. And you also understand, although this says, county cap at the time of sentencing, that there is, because it's an operating while intoxicated. Third, there is a mandatory jail time of 30 days. If I put you on probation, 30 days to 1 year in jail. And we'll talk about that at sentencing. At least 45 or 48 hours would have to be served consecutively. So we'll talk about how that works.
Yes, ma'am.
Okay, how long have you been incarcerated now?
I think 86 days.
Oh, all right, so we've already met that. Okay, thank you. Sir, did these offenses occur on or about November 8th, 2019
Yes, ma'am.
in the city of East Lansing, County of Hingham, State of Michigan?
Yes, ma'am.
At a specific location known as Lake Lansing Road and Harrison Road, you came in contact with law enforcement?
Yes, ma'am.
Had you been operating a motor vehicle
Yes.
on a public road or highway?
Yes, ma'am.
You would agree that Harrison and Lake Lansing is a public road?
Yes,
And you had consumed alcohol prior to entering that vehicle?
I did.
Do you recall what you had consumed?
A few drinks.
Okay.
Oh, liquor.
Liquor,
Yeah.
okay. And you would agree with me that had you not consumed alcohol, you would have driven better?
Yes, ma'am.
And you were stopped because of your driving, is that correct, or was there an accident?
No, there's no accident, just pulled over.
Okay, and then when officers came in contact with you, did they ask you to step out of the motor vehicle?
Yes, ma'am.
Did they ask you to perform the field sobriety tests?
Yes,
And did you do those?
I believe so.
Did they give you a breathalyzer at that time, or did they take you to the station and do a test on the dead mass?
I think they did it at the station. It was in
Okay,
East Lansing.
okay. And so you weren't very far from there, so they took you to the station, and do you recall the reading of that? Counsel, do you have it?
I do, Your Honor. Here.
0.12.
And counsel, you're not contesting that that is above the legal limit?
No,
So you understand that was above the legal limit?
Yes.
All right, and you had previously been convicted of operating while intoxicated on or about July 23rd, 2013 in the 55th District Court,
Yes, ma'am.
and also on or about January 4th, 2012 in the 56th District Court.
Yes, ma'am.
So you would agree that this is at least your third operating while intoxicated?
Yes,
All right, and at that time, you also had a firearm in your possession, is that true?
the third offense?
No, just,
No.
well, during that stop, you also had,
during that stop.
The last one, yes, I did.
okay, so did you give officers permission to search your vehicle?
I believe they towed it.
Okay, and so when they subsequently searched your vehicle?
Yes,
They found a firearm in there?
yes, ma'am.
Do you recall what kind of firearm it was?
380?
Okay, and it's fair to say you didn't have a license or special permission or authority to have that in your possession, is
No.
that correct? And that's because you had been convicted of possession of a controlled substance, delivery, manufacture of a controlled substance less than 50 grams,
Yes,
and the time had not yet passed where you could apply for carry license, correct?
yes,
Okay, and you had placed that weapon in your vehicle
yes,
and it was under your control?
yes.
Do you remember where it was located?
It was in the council.
Okay, thank you. On behalf of the people, any additional questions?
People are satisfied, Your Honor.
Council?
No,
Thank you. Our council where promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
no.
Score complied with the court rule.
You have, Your Honor.
Yes.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, counts 1 and 3 will enter. Counts 2, 4, 5, 6, 7, and the habitual second are dismissed in their entirety, and count 1 will enter as the OUI third. Any outstanding warrants related to this file, if any, are hereby recalled and dismissed. All weapons and contraband are hereby forfeited. And as to the vehicle, it will be immobilized pursuant to the statute. We'll talk about that in sentencing. Counsel, I'm sure you can have that conversation with him. All right, do you have a sentencing date?
September 30th at 10:00 a.m.
Okay.
All right, sir, are you employed? What's your status?
Yes, I'm a business owner,
What do you do?
paint and flooring.
Okay,
Your Honor, and just to clarify, I don't know if I missed it, did you would forfeit all weapons and contraband?
yes.
Okay,
It just,
Thank you.
yeah. So what have you been doing? You've been gone for what, 7 years? What have you been doing during that time?
I went to Texas for a little over a year and didn't work out, so I kind of came back and sobered myself up and started a business.
So how long have you been clean?
It was 4 years, it was right after COVID, and then I had a relapse in January of 25th. And then that was a 4-day, and then I've been clean since.
So you're going to AA, NA, CA, what are you doing?
I signed up, I'm doing seeking safety, restorative justice. I did, signed up for MRT. And then I tried CATS, but they said I didn't meet the criteria.
Okay, and so do you still live on Dorian Drive?
Yes, ma'am,
Okay, and who lives there with you?
my wife and my
Okay.
kids.
So is intent to keep him in lockup or to release him?
the concern that we have, Your Honor, is that obviously this case is from 2019. He FTA back in 2019, and then or never mind, he FTA back in 2020, in January of 2020, and only showed back up now. So the people are just concerned that he would be a flight risk if he is let out prior to sentencing.
So was he picked up on a bench warrant or did he turn himself in? Sir, what'd you do? Did you turn yourself in or?
No, they pulled me over.
So why did you forget about us for so long? I mean, you may have had this.
Like I said, I was just trying to get my life back together. And I was eventually gonna, when I got my money right and everything, come in. Right now, my business is kind of struggling, so I was hoping for a bond reduction.
And it is correct, Your Honor, I just wanted to put on the record that, I don't see his family here today, but they were here yesterday, his wife and kids were.
Yeah, she couldn't make it today.
I don't care if the whole fleet shows up. I care about you showing up.
Yes,
Does it
ma'am.
mean anything to me that your kids get to see you in that prison guard or jail guard? I don't think that's good for kids to see, but, good that you have their support, but you should have cleaned this up in 2019.
Yes, ma'am.
Any alcohol in your home?
No,
Any weapons in your home?
no,
Any felons in your home?
no, it's just me.
All right, so I'm giving you a $50,000 PR bond to report to pretrial services as directed, no less than weekly. You are going to be placed on a scram tether, and that's so we can make sure you're not using any alcohol. So you need to plug that in, not obstruct it, follow those rules, and then we'll talk about how long that stays on at the time of sentencing, see how well or how poorly you do. You shall not use, possess, consume, purchase, or be in the presence of any illegal drugs, alcohol, drug paraphernalia. If you have the need for any of those things, you'll present a prescription from a licensed medical physician within 24 hours. You will PBT and or drug test as requested by pretrial services, law enforcement, any court officer, or your wife. I don't see the need for regular testing because you'll have that scram tether on, but if somebody wants you to do a test, you will do that. You will not have in your possession, under your control, or in your presence a weapon, gun, ammunition, imitation of a weapon. You will not use any object as a weapon. You will maintain your current residence, and any address change will be reported to pretrial services, the court, and your counsel within 24 hours. Your next court date is September 30th at 10 a.m., and you will submit to a substance abuse assessment and complete the pre-sentence investigation report with probation. Counsel, I don't care if you want to send them over to PATS for the assessment or probation does it, or however you want to do it. I just want to make sure he's handled whatever's going on, and maybe he just needs aftercare, maybe he needs something more intense, I don't know. Sir, you will need to come back to this building within 24 hours, go downstairs, just hit G on the elevator, go downstairs, probation's down there, make and keep an appointment. You can also call them, it's on the purple sheet we're going to give you, and I'll write the number on the sheet as well. Their phone number is 517-483-6100. However, sometimes it can be difficult to reach them over the phone. You must make an appointment. You must keep that appointment. If you do not, then I can't get to sentencing. They're going to do a detailed report. If you forget about doing that, I simply have you arrested. You'll sit in that jail a few more months until they decide to come see you. That's up to you.
So this is something I can do tomorrow morning?
Yes.
Okay.
Anything further?
No, Your Honor, thank you.
No, thank you.
Thank you. Good luck to you, sir.
When you get out, okay? We got to do that, please. You have to.
Alexander Clemens.
This is docket 25-2255-FH and docket 25-2257-FH. People of the state of Michigan versus Alex Clement. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Assistant Public Defender Sarah Donnelly on behalf of the defendant Alex Clement, who stands to my right.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth, and the penalty of perjury?
I do.
Thank you. Put your hand down. And I have you at, let me see, 510 North Cedar Street. Is that-
That PR bond says I can't go back, and I was evicted and I got the charges.
So are you homeless?
Yes. I use a shelter as my mailing address, the Nest.
So what is that, the shelter you use for
That's my mailing address,
It's right across the street, the day program.
Okay, what's the address there?
Do we know which it is?
no, not off the top of my head.
The address is at 332 Townsend Street. 48933.
All right, have you taken any medication yesterday or today? I don't need to know what, just have you?
Yes,
taken-
I have.
Does that medication interfere with your ability to understand your attorney or the court?
No, no,
Is there any medication you're supposed to take that you're not on?
no, no,
Any sign of fever, COVID, or other illness?
no, no,
All right, you had enough time to speak with your attorney,
yes.
and this is going to be a plea today, is that correct?
Yes.
All right, were you on probation, parole, or bond conditions at the time of this?
Yes, and I had a probation violation in district court earlier.
Okay, so there's a district court file plus these two files in front of me.
The probation file was discharged unsuccessfully, Your Honor. There is another case in district court that we have basically an offer on right now, but it happened after this incident.
Before,
What did it happen? But before you were on bond?
right, yeah, before I was in bond, yeah.
Okay, and are you a US citizen?
I am. Born in Elkhorn.
And what is the plea agreement?
Yes, Your Honor. The defendant be pleading on 25-2255 to count 1, malicious destruction of personal property, 1,000 to 20,000. Upon successful plea and sentencing, count 2, the larceny in a building, as well as the entirety of 25-2557-FH will be dismissed. There is an agreement to no upfront jail at the time of sentencing. However, the defendant will complete a term of probation. And restitution will be on both files in the amount of approximately $10,000, but we determined the exact amount of time of sentencing.
Okay, thank you. Full, fair, accurate, and complete?
Yes.
Full, fair, accurate, and complete? Is that a yes?
Yes.
Okay, you have to speak up because a record's being made, and when you're not, she would have to guess, and she's not allowed to do that. The record's for you, not me, okay?
Understand.
All right. And were you high or drunk or?
I was really out of it, to be honest. I've been through a lot, like I lost my job a week before, I've been arrested 5 times. I was doing a little bit of crack, but I don't think I was high at the time. I think I was like coming down or anything.
Okay, so given that, I have a lot of questions to ask you, and council may have some. Do you remember what happened, or do we need to use a
Yes,
police
I
report?
remember,
So
I was.
we'll ask you questions. I just wanted to make sure that the record that we're making is from your memory, that you're not guessing. So you're okay with, okay, very good. Council, are you waiving reading count 2 and then the entire case of 25-2557 FH?
Yes, Your Honor.
Thank you. Ask to count 1.
Yes, Your Honor. People of the state of Michigan versus Alexander Leroy Clement, State of Michigan, County of Hingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 1, malicious destruction of personal property, 1,000 or more but less than 20,000. On or about March 29, 2025, at 510 North Cedar Street, Lansing, Michigan, 48933, Ingham County, State of Michigan, the defendant did willfully and maliciously destroy or injure glass interior doors, window screens, fire extinguisher cases, computers and monitors, TVs and blinds, and the personal property of Stadium North Lofts, and the amount of destruction or injury was $1,000 or more, but less than 20,000, contrary to statute. This is a felony that is punishable up to a maximum of 5 years and or $10,000, or 3 times the amount of destruction, whichever is greater. Court shall order law enforcement to collect DNA identification profile sample for sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan.
Did you understand what was just read?
Yes,
So you understand malicious destruction of personal property, $1,000 or more, but less than $20,000 is a felony punishable by 5 years?
yes,
and you'll be responsible to pay the restitution. If the amount is something you disagree with, we'll just have a restitution hearing and I will decide the amount. The amount can go up, it can go down. Do you understand
I
that?
do.
All right. It looks like you signed the advice of rights form. Did you read it before you signed it?
Yeah, we talked about it.
Did you understand what you read?
I did.
And if you had any questions, your attorney was able to answer those?
Yes.
Do you have any questions about your rights?
No, I did not.
And you've decided to plead, is that correct? Did anyone force, threaten, or coerce you to make this decision?
I did not.
Did anyone promise you anything other than what was placed on the record?
No.
And you chose to plead after you spoke with your attorney?
Yes.
And you've been satisfied with the representation of your attorney?
Yes.
As to malicious destruction of personal property, $1,000 or more, but less than $20,000, count one, how do you plead?
Guilty.
Do you understand that by pleading, you're giving up your automatic right of appeal, so that now you have to ask permission of the Court of Appeals to appeal? Had you had a bench or jury trial, if you were unhappy for any reason, they would have to take a look at your case, but now it's their decision. Do you understand that?
They got me dead to rights. I understand, Your Honor.
I'm sorry.
I said they got me dead to rights. I understand, Your Honor.
And you understand you're also giving up the holding of the people to their burden of beyond reasonable doubt. You're giving up the presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to choose to provide a defense, etc.
Yes.
All right. And if you violate the law or binding conditions between now and sentencing, I don't have to agree with this recommendation for no upfront jailing or probation. So if that happens, you're entitled to a hearing. If I decide you were in violation, then this agreement goes out the door. Do you understand
I
that?
did.
All right, very good. Has anyone told you what I will do at sentencing?
No.
I'll make up my mind when I'm fully informed. Right now, I know very little. Okay. Did this offense occur on or about March 29th, 2025?
I can't remember the specific date, but that sounds right.
In the city of Lansing County of Bingham State of Michigan?
Yes.
At a specific location known as 510 North Cedar Street in Lansing?
Yes.
Is that a building?
It was my apartment building.
And was it your apartment or the building?
No, it was the building. It was the common room in the landlord's office.
Okay, and did you get upset and destroy or injure glass interior doors, window screens, fire extinguisher cases, computer monitors, TV, and blinds?
I was a little, I don't even know how to explain it, but yeah, I did destroy those things.
Okay, and you would agree that that was not your personal property,
Yes.
but rather the property of Stadium North Lofts?
Absolutely.
And you caused, combined with all of those things, you combined damage, the value of the damage combined was $1,000 or more, but less than 20,000?
Sounds right.
On behalf of the people, any additional questions?
People are satisfied, Your Honor.
On behalf of your client,
No additional questions.
thank you. Our counsel where promises, threats, or inducements other than those already placed on the record,
No, Your Honor.
No.
has court complied with the court rule?
You have, Your Honor.
Yes.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threat, coercion, or promises of leniency. I also find there sufficient grounds to accept defendant's plea. Therefore, count one will enter on docket 252255 FH. Count two is hereby dismissed. And the entire file of 252557 FH is dismissed with the exception of any restitution will be transferred over to this file, if any. Any contraband that was seized, if there was any on either files, hereby forfeited. We have a sentencing date,
September 30th at 10:30 a.m.
It's a popular day.
that each is scheduled,
Yes, Your Honor.
and what you'll need to do is go downstairs and make and keep an appointment with probation. They're going to do a very detailed pre-sentence investigation report. I can't proceed without it, so if you choose to not do it, I'll have you arrested and then we'll just detain you in jail
What's the
until it
deadline?
gets done. What is it?
When did you say the deadline, like 24 hours?
24 hours.
I'm gonna take
If
you
you can just
downstairs.
go downstairs and make it, it's a lot easier.
Get it over with.
Yes.
Yeah, no, if you're in the building, take 5 minutes, otherwise you're gonna be spending an hour, you're dialing until you actually reach a human. We're gonna give you that purple sheet, which will give you notice of date.
Okay.
All right,
Do I still have to show up the free trial every 2 weeks?
but you still have to call
Yes,
for
you're still on
services.
bond.
Yes. How are you doing with drug use?
I'm doing pretty good.
Are you in treatment?
No, but,
She has completed Meridian, recently and has done other, residential treatments.
And what about, do you have a place to live?
no, I'm not.
So are you just going to shelter or what?
Last night she was, out on the street and unfortunately got all her stuff taken, so.
Yeah.
So she was gonna go over to the nest to see if they can help her get her ID back.
Okay. Yeah, you're gonna have to have an ID, so,
Yes.
um,
I wanna get a job and, you know.
do you have
stay-
family in the area?
They're in Flint. I grew up here, but, yeah, they're all in Flint now.
So can you live with them in Flint or no?
No, I'm not allowed at my mom's.
Okay, do you have anybody in town? Okay, have you talked to, is she working with your social worker
I was having her, yeah, but Beth has left now, so I can, if you want, yes, I'd have her work with Sophia, you know.
That'd be great.
Yes.
Yeah, there are some options and, how about, have you applied for public assistance?
No. I should.
If you apply, they do have emergency funds where you can get a hotel room.
Really?
Yeah, you need to, that's why we pay taxes, so that people like you who are homeless and down on your luck can get a place to live. You don't have to live on the street. It's dangerous for you to do that. So you need to fill out the paperwork. And get they give you like a voucher for a hotel for a certain amount of nights and all that, but you have to ask for it. Not asking for it means you're out on the streets and begging for money. So does your social worker can help her fill that out or?
Yeah, yes, we have, what we need to do with Alex is, because she doesn't have a phone, is, have her come to my office and work with my social worker.
You're in
So-
South Washington.
Yeah, right next to Louis
So-
Grocery Store now.
You need to get over there because you can also get free phone. There's so many things that you can get, but you have to start the process and you have to stay clean. Okay, are you having trouble staying clean? Okay. Thank you.
Now, Takesha Culver syndrome.
What is this going to be? Is this going to be another thing?
Yes.
Is it under?
Doesn't matter. So do we have any civil today? Just that one, right? Oh.
Phone number on that. You want?
316, 5,
It's too many numbers.
no, that's not, it's not 517. I'm at the same area code 32.
Huh?
I don't see civil line here.
Oh,
What's
30,
the-
okay. Sorry, yeah.
That's why I just wondered if it was any.
I thought you said.
316.
Area code is 32.
Yeah, 316.
Um,
You're talking about the F word.
Okay.
Yeah.
And it's in here, Lansing.
Yeah, I put the script on the upward, made a lot of good work out of that.
Okay. And then this is the partnerships you.
I just lighten up the, you know, people seem to like it, considering I made it up in about 10 minutes. You know, I can talk about it. I only gave me 10 minutes, so this is it, but if you wanna hear the story behind each one of those things, invite me over for an hour or two.
Here.
Fine, yeah.
And your address.
7:35.
Over at Saginaw first. Closer. Sure. And it's, yeah.
Thank you.
6, 5.
Are they still in
Which are. Yeah.
Oh, yeah.
With the advisory rights and the
Yeah.
agreement.
All right, this is docket 263863 FH, 263418 FH, people of the state of Michigan versus Takesha Culberson. Or Culberson, is that right?
Yes, yeah, yes, yes, ma'am, yes, ma'am.
Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, I'm Dwayne Sullivan from the Office of Public Defender on behalf of Takesha Elaine Culberson, who's standing to my right at council table. I am appearing on 263418, and I'm appearing on behalf of Jonathan Foreman and 263863 FH.
Would you be here for sentencing?
I can be here for sentencing in both cases, yes, sure.
Okay, great. Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes,
Thank you. Put your hand down. You taking any medication yesterday or today?
yes,
Is it anything that would interfere in your ability to understand your attorney or this court?
no,
Is there medication you're supposed to be on that you're not on?
no,
Any sign of fever, COVID, or other illness?
No.
And counsel, you believe she's oriented to date, time, and place, and does understand what's occurring?
Yes, I believe so, Your Honor.
I do as well. She's got good body language. She's been able to answer all the questions appropriately, good eye contact. Therefore, we will proceed. Ma'am, I understand there's going to be a plea today. Were you on probation, parole, or bond conditions on other files at the time of these events?
I don't think so, but, PR and, no,
Was there an open file in Grand Rapids when these occurred?
when I, no.
Here's
this
why
is-
I'm asking.
No,
So-
it's a new one, I just had that one, and then they found out I had these ones. and they-
So did they deal with that with you already?
I got
okay.
PR.
I'm sorry?
I have a PR on, that case.
Okay, so the reason I'm asking is because if you had another file open and you got these, then they could do a violation of you. So do you understand that?
I know, I have a personal recognizance, I don't have.
Them, I'm talking about something.
Your Honor, can I help?
Yes, please.
These offenses, the Grand Rapids offense occurred after these offenses, is that correct?
Yeah.
So you couldn't have been on bond in that case?
No, I just, when she told me, I thought about it, no, it was, It was after.
It was after, so there was nothing pending at the time of these.
No,
Oh, okay, that's why, that's what I need to know. Thank you, guys. And you're a US citizen?
yes.
And where do you live? I have your address unknown.
It's 735 West Chicago, Avenue, Lansing, Michigan, 48915.
Who lives there with you?
My husband.
And there's a whole lot of alias names here.
I don't have an alias name. I go by Taquisha Culberson at all times, or Quisha for short, really.
Okay, and your middle name is Elaine,
Yes, ma'am.
Elaine?
No, ELANE.
Okay. That is one of the versions of your name. Probably you don't have aliases, it's everybody got your name spelled wrong and they called it aliases.
Oh, no, I definitely don't go by that. Everybody calls me.
Oh, okay, so I'm just gonna cross all that mess out. Okay. I'll probably get it wrong in the PSR, so.
Yes, and for the record, I need to know, I'm seeing where the court is addressing it on the felony complaint, and it appears that they're all various spellings of the same name.
Right.
With it,
So-
sometimes with an I and sometimes Elaine is ELANE and sometimes it's ELAINE.
So let's just verify, the spelling of your name is TAQUESHIA,
Yes,
and then Elaine is ELANE, and Culberson is CULVERSON.
yes.
Okay, because what they do is they do a whole bunch of spelling variations, so I
Well,
crossed
they
them
probably
out.
just don't know me, or they haven't seen the birth certificate, that's all.
They always spell my name wrong too, so
That's what I-
I guess I would probably have about 15 aliases if they counted all, everybody's misspellings, but
Right.
it's all the same name, which is weird that they would give you an alias, they should
'Cause I-
just put spelling errors.
Right, yeah, that's what.
But it's okay, just wanted to clear it up, so then on the pre-sentence investigation report, that follows you, so that we get your name correct there, so I made a note, we'll have to look at that, and I know your attorney's very good at that, and he'll remind me too, okay? All right, so I understand there's a plea agreement, have you participated in that with your attorney, correct?
Yes,
And did anyone force, threaten, or coerce you to make this agreement?
no,
Anyone promise you anything other than the plea agreement in order for you to plead?
no,
And you decided to plead after you spoke with your attorney?
yes,
And you've been satisfied with the representation of Mr. Silverthorne?
yes.
All right, thank you. On behalf of the people, what is the plea agreement?
Yes, Your Honor, there'll be a global resolution in this matter. In 26-3418-FH, the defendant be pleading to count 1, possession of a financial transaction device. And upon successful plea and sentencing, the habitual fourth will be dismissed. In file number 26-3863-FH, the defendant be pleading to count 1, resisting obstructing a police officer. And upon successful plea and sentencing, count 2, another resisting obstructing a police officer. Count 3, disorderly person jostling, and habitual fourth offender will be dismissed. There is an agreement to no upfront jail at the time of sentencing, and any restitution will be determined at the time of sentencing.
All right, and counsel, is that full, fair, accurate, and complete?
Yes, Your Honor, it is.
Is that full, fair, accurate, and complete, ma'am?
Yes,
All right, and counsel, you're waiving reading the habitual fourth on the 3418 docket?
Yes, we were reading,
And,
we're reading the dismissed complaint.
and then on the 3863, you're waiving reading of counts 2 and 3 in the habitual fourth?
Yes, Your Honor.
And ma'am, during any of these events, were you intoxicated or high?
maybe, yeah, a
Okay.
little bit, well, both, one sober, one not, what was in both?
Well, you would be the one that knows, but
Yes.
regardless, will you, I'm gonna have to ask you a lot of questions, and so will your
Okay.
attorney, okay?
I just try to remember.
Yeah, you gotta just let me talk, because the court reporter's gonna get confused, and so one at a time, okay? So, my question is, do you remember the events?
I just, I do remember, but, cause I had so many cases, but, yes, those two, that's how I caught them, I was under the influence.
Okay, and I suspected that, I don't have that information in front of me, but the questions that I'm going to be asking you, do you remember them, or do you remember these events of your own free will, or was your mind so clouded that we have to use something else to remind you?
No, I just had to think about it because I didn't know you was going to ask me that. It was like,
Okay, so you remember these events of your own free
Yeah,
will, of your own mind?
Yes.
Okay, very good. As to the reading of the felony information.
Yes, Your Honor. File number 26-3418-FH, People of the State of Michigan versus Takesha Elaine Culberson, State of Michigan, County of Hingham, in the name of the people of the State of Michigan. The prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 1, financial transaction device possession, on or about January 18th, 2026, at 314 South Pennsylvania Avenue, Lansing, Michigan, 48912, Ingham County, State of Michigan, the defendant did have in possession or under control or receive from another person a financial transaction device issued by MSU FCU with the intent to use, deliver, circulate, or sell the same, or to permit, cause, or procure the same to be used, delivered, circulated, or sold, knowing such possession, control, or receipt to be without consent of the device holder, contrary to statute. This is a felony that is punishable up to a maximum of 4 years and/or $5,000. Court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan. And in 26-3863-FH, People of the State of Michigan versus Takesha Elaine Culberson, State of Michigan, County of Hingham, in the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 1, police officer / first responder, assaulting / resisting / obstructing. On or about February 14th, 2026, at Albert Street and Abbott Road, East Lansing, Michigan, 48823, Ingham County, State of Michigan, the defendant did assault, batter, wound, resist, obstruct, oppose, or endanger J.C. Kingsbury, a police officer of the East Lansing Police Department, and the defendant knew or had reason to know was performing his or her duties contrary to statute. This is a felony that is punishable up to a maximum of 2 years and/or $2,000. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D subsection 6 for another violation arising from the same transaction. Court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan.
Did you understand what was just read?
yes, Karen, I do.
So you understand in docket 26-3418, count 1, financial transaction device possession is a felony punishable by 4 years and/or $5,000 plus restitution for any loss or damage. And if you disagree with the amount of restitution, we'll have a restitution hearing. I will determine the amount after a hearing. The amount can go up and can go down. Do you understand that?
Yes,
And then on docket 26-3863-FH, count 1, police officer, first responder, assaulting, resisting, obstructing. That is a felony punishable by 2 years and/or $2,000. Again, you might be responsible to pay for any personal or property loss or damage or prosecution. Do you understand?
yes,
Okay. And looks like you signed the advice of rights form. Did you read it before you signed it?
yes, I
Did you
did.
understand what you read?
Yes,
And if you had any questions, your attorney was able to answer those?
yes,
And do you have any questions about your rights of me?
no,
As to docket 26-3418-FH, how do you plead to count 1, financial transaction device possession?
guilty,
As to docket 26-3863-FH, count 1, police officer, first responder, assaulting, resisting, obstructing.
guilty,
And do you understand that by pleading, you're giving up your automatic right of appeal? If you choose to appeal, you first have to ask permission of the Court of Appeals to appeal. And they don't have to allow you to appeal, it becomes their decision. Had you gone to bench trial or jury trial and were unhappy, then they would have to take a look at your unhappiness, but now they don't. Do you understand that?
Yes,
Do you understand you're giving up the presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to choose to provide a defense, and to hold the people to their burden of beyond a reasonable doubt, you're giving up all of those things as well.
yes.
Has anyone told you what I will do at sentencing?
Yes, ma'am.
Well, have they promised you what I will do at sentencing?
Oh, no.
Okay, you have a very good attorney. I've known him for decades and decades, and I know he prepares you well. I'm sure he's gone over options, but he or no one has promised you what I'll do, right?
Mm,
Okay, so, and that's because I don't even know until I'm fully informed. Right now, I'm not fully informed. Do you understand that?
I understand.
Now, if you violate the law or bond conditions between now and sentencing, I do not have to honor this plea agreement. Do you understand that?
Yes, sure.
All right, let's start with the 263418 FH file. Did this offense occur, that's a financial transaction device? Did this offense occur on or about January 18th, 2026?
Yes,
In the city of Lansing County, Bingham, state of Michigan?
yes,
Did you have in your possession or under your control a financial transaction device that was issued by MSU FCU?
yes,
And did it belong to someone else?
yes,
And did you attempt to use it?
yes,
And you did that to defraud the owner of the account and MSU FCU of money, I suppose?
yes.
And did you actually receive any money?
Food items, yes.
You bought food with that?
Yes.
Card, okay? And you didn't have any right or entitlement to use of that card to purchase that food, is that correct?
Yes,
All right, and in regard to this file, any additional questions on behalf of the people?
People are satisfied, Your Honor.
Counsel?
Defense is satisfied, thank you, Your Honor.
Let's move over to the other file, and ma'am, did this offense occur on or about February 14th, 2026
yes,
in the city of East Lansing County, Bingham State, Michigan,
yes,
at a specific location known as Albert Street and Abbott Road?
yes,
And did you come in contact with law enforcement?
yes,
And you might not have known the name, but counsel, would you stipulate that it was J-A-C-E-Y Kingsbury, Kingsbury?
yes.
Yes, Your Honor.
And was that a police officer?
Yes,
And you knew that because he was wearing a uniform
yes,
in a marked vehicle?
yes,
And did you do something to interfere with him performing his duties?
yes.
What did you do?
I resisted arrest. I tried to fight back with him or get away because I didn't want to be arrested.
And you understood that by resisting or obstructing what he was trying to do, you endangered yourself, him, and others?
No, I do, yes.
Okay, and you understood that he was performing his duties and that you needed to cooperate?
Yes,
All right. On behalf of the people, any additional questions?
No, Your Honor.
On behalf of the defendant?
No, Your Honor.
Thank you. Our counsel, waiver promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
No, Your Honor.
Does court comply with court rule?
You have, Your Honor.
Yes, Your Honor.
I find defendant's plea on each file has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, on each trial, count one will enter, and then on docket 3863, counts 2 and 3 are hereby dismissed, and on each file, the habitual fourth offense notice is dismissed. So what remains is count 1 to be entered on each file. Any outstanding words on each file, if any, are hereby recalled and dismissed. Any contraband seized, weapons, I don't think there was any, but any contraband seized, drugs, alcohol, whatever it was, is hereby forfeited. And And do we have a sentencing date?
September 30th at 11 o'clock.
Is that meet with your schedule?
It does, Your Honor.
All right, and ma'am, you're going to have to cooperate with probation, they're going to come and see you, or are we talking about bond?
Yes, Your Honor.
All right, so if you're released, you'll have to come back to this building and make an appointment with them, or you can call them, you'll have 24 hours to do that, ma'am, okay?
Okay,
All right, in regard to bond,
Yes, she's been, and I've been contacted several times by someone from the health department, the Lincoln County Health Department, advocating on her behalf, and she's also been involved with the CATS program that wants to get her into inpatient treatment just as soon as she can get out. Judge Babcock has given her a $5,000 cash, or excuse me, $5,000 PR bond in her case, and Ms. Culture reports that she has a PR bond in the Grand Rapids case, which she wants to take care of. She has a very low cash surety bond. I think it may only be a 200 cash surety, but even that amount she can't make. She's been in jail for, I think, over 2 months now. Given that there's no upfront jail, I will report that what was taken was about $11.06 worth of snack items, Cheetos and things like that. That's probably more appropriate, I agree, for sentencing, but still, I just want to let the court know that, the magnitude of what occurred, at least in the financial transaction device case, where the real harm was the taking of the card itself. And for all these reasons, I'd ask that the court would give her a PR bond, but you can condition it that the PR bond would take effect when CATS is able to have you transported to inpatient. Is that correct?
well, she can give me the PR, that's gonna happen regardless, because they're not gonna do it unless she releases me. She.
oh, I know how to do this, let's get to the other business.
Yes,
Okay.
ma'am, thank you.
Okay,
On behalf of the people, what would you like me to know?
Your Honor, if it is subject to having her sent to inpatient treatment, the people would be in agreement with that. Looking over specifically the resisting and obstructing case, it does appear that she was under the influence of something at the time. So we do believe that would be appropriate.
So ma'am, is this alcohol, drugs, what's your problem?
Yeah, after. But I don't do that anymore. I've been very sober and I haven't caught any more cases. The only reason why I caught the one in Grand Rapids is that I was resisting because I wasn't doing anything. I was in the midst of something. I was walking down the street. He put me in the midst of it, but he ran my name. And,
Okay.
and he arrested me for these warrants. That's why I'm here. But
Okay.
I haven't been doing that.
Well, I'm glad you're here, and you're not drinking. So
Me too.
tell me about, you got a husband at home?
Yes, but
You got kids at home?
I do, but
How old are they?
they're not with me right now.
How old are they?
He's 15.
He's 15, is he with dad?
Yes,
Okay, are you still married, or are you pending divorce, what?
I'm still married.
Okay, so why weren't you at home with your husband and your son?
I was walking home and I was actually attacked by a group of people and they called the police. They were messing with me because the drink was in my pocket and it was in my chest. And then
Are you talking about Grand Rapids or here?
in Lansing, yeah, it was a dispute and I was being harassed and that's how it got on the ground and I was sharing it with them because they seen me come out the store with it. And they're like, hey guys, something, but I learned my lesson. I didn't.
Okay, ma'am,
Mhm.
so you got this transaction device and you've taken food. Why didn't you have money for food? Is your husband not working?
Oh, no, well, I don't really be at home, but that situation,
So
it had
wait,
something.
let's stop there.
I was talking about the resist, I wasn't talking about the.
I'm talking about globally. I want to see what's going on with you, okay?
I wasn't.
Give me a couple of minutes.
Okay.
I don't need the whole backstory of all your cases.
I
Why
wasn't-
are you not living at home with your husband and raising your son? Is there a problem in the marriage? Is there domestic violence? Is something else going on?
There's nothing wrong, I just need to just stop hanging out, that's it.
So you're prioritizing your alcohol and your friends and your streets over your husband and your child?
No, I'm not. Your
Well,
Honor.
that's what it sounds like to me. So tell me, is there something going
I made
on?
a mistake, Your Honor, that's all I can say, I'm young, so I don't know.
Man, you made lots of mistakes.
But that's
So-
all I can say, Your Honor, I don't know, I'm
Okay.
not gonna make up nothing.
So is protective services involved in your home or no?
No,
And is your husband working? So you couldn't have gone to him and asked him for some food?
I mean, I didn't really know, I never done that before, so the guy stole it or whatever. And I was trying to get police attention, I was really reporting those cars because he had robbed her and then I had.
Okay.
Miss-
But
Miss
ma'am, you
Culbertson,
used.
Your Honor, may I-
Yeah.
I didn't know no better.
Ms. Culbertson,
I know I did it, but
Ms.
I don't.
Culbertson,
Yes.
you're not correctly answering the
I
question.
don't know how to answer because I
The
told him.
judge is being generous
Okay,
with
go
me, but
ahead.
I wouldn't let you do it on the stand. Answer her questions, please.
I'm trying to.
Well,
I'm
ma'am,
not being-
I understand there's a whole lot of things going on here. You've pleaded these counts. I don't care about
Yeah,
anything.
I did.
Stop. You may have, I don't know what's going on in Grand Rapids. They could get a copy of this. I don't want you to talk about that. I want to know what stopped you from going home to eat? Why did
I
you
don't
use
know.
this card? You don't know.
I know that I didn't at the time. I
Okay.
wasn't thinking straight. That's
Okay,
all I
stop
know.
there. So now, were you not thinking straight because you had too much to drink?
Yes.
How long you been drinking?
I can't really, I mean, a while.
How old are you?
I'm 33 years old,
So how many years you been drinking?
like a few.
Like 13?
I don't keep.
Since you were a teenager or what?
Yeah, 17, yeah. I don't count all that stuff. I don't be thinking straight sometimes. That's all that is, and I apologize.
Are you supposed to be on psychotropic medication?
Yes, I am, but it was, like I
Do
said,
you have a diagnosis?
yes, Your Honor, I didn't mean it.
Okay, wait a minute. So, do you know what your diagnosis is? Are you bipolar, schizophrenic? Are you just an alcoholic? Do you know what's going on with you?
Bipolar, schizophrenic, ADHD, and
Okay, that explains a lot. That's why I'm asking this. I want to get you the right help. And I don't have any assessments right now, but I'm going to send you for treatment. But I'm going to ask that you be reviewed.
I'm
So-
on medicine right now already through CAT.
Through cancer medicine
It
or
For bipolar.
for all? And how are you doing on that medicine?
I'm doing actually very well. It goes with me to rehab today, because I've been to rehab before. They let you, it's through CMH, they let you take your medicine. I'm there too, so they'll give it to me.
Okay, that's why I'm asking him.
Okay. I apologize.
No, that's no problem. Okay, ma'am, I'm going to give you a $10,000 PR bond upon acceptance of inpatient long-term residential treatment where you can take your psychotropic meds. There are some facilities that will not treat you if you're on psychotropic meds, and I suspected you were on. That's why I was asking you, because you've got alcoholism, you've got some mental illness going on, and so there are some treatment facilities that are better than others. And I want to make sure we get you to the one that can treat you as a whole person,
Right.
okay? And that's why I was asking, okay?
Thank you. Yeah. Could you make sure that you put in there a rehabilitation treatment center?
That's what I did, is it's gonna be long-term, it's inpatient, residential, it's for rehabilitation, okay?
Thank you.
All right, ma'am. You'll be released to inpatient long-term residential treatment where you come to take your psychotropic meds. You'll report to pretrial services upon release if that is if you haven't been sentenced yet. So once you're sentenced, it'll go to probation, prior it goes to pretrial. I suspect you'll be sentenced before you're released, but I don't manage every department, so I don't know. Does that make sense to you?
Yes.
You shall not use, possess, consume, or be in the presence of illegal drugs, alcohol, or drug paraphernalia. If you have the need for any of those things, you'll present a prescription from a licensed medical physician within 24 hours. You will be placed on a scram tether upon release of the treatment facility. You will PBT and/or drug test as requested by pretrial services, probation, law enforcement, any court officer, or your husband.
The rehab drops us every 2 weeks anyway.
Well, I don't know, you'll be in a rehab facility, I don't know what.
So do I have to pay for it? Cause I can't afford anything, that's what it's saying. Or will my probation officer do it?
They'll work with all of that with you, okay? And if they do something where you can't afford it, then tell your attorney or come back and talk to me and we'll figure it out. There's options, okay? So we have an indigency fund for certain tethers, and I believe Scram is one of those. If not, we'll talk further, okay? You shall not own, have in your possession or under control any weapon, gun, ammunition, imitation, or other weapon. You'll not be in the presence of anyone who has those items. You'll not be in the presence of any known gang members or any gang colors, insignia, or gang tattoos. You will maintain your residence. That will be with your husband. If not, if you are no longer living with him, we know each and every address. So 24 hours, tell that to us. You will complete all aftercare.
What does that mean?
That means that when you are done with your program, they're going to tell you to go to AA, NACA. They might have you tested. They might have you do trauma treatment. They might have you do EMDR treatment. There's all sorts of things they can recommend. Those recommendations become orders of this court, and you must follow that, okay? So, ma'am, you'll be in front of me September 30th at 11. Do you agree to, would you like to be brought from the program you're in, or is it okay to do by Zoom?
If they can transport me, I'll come.
So you want to be in person?
Yeah, I'd rather do, because I
Okay.
can't, I don't wanna mess up a Zoom and not show it, I don't really know nothing about it. I think it's easier that if I can't get a ride, I can catch the bus and I know that
Well, you can't catch a bus from treatment. I suspect you'll still be in treatment.
No, I'm talking about either way, I can show up.
It might be easier to do it by Zoom. Facilities are very familiar, and they'll set you up, basically put you in front of the screen, and the judge will simply appear, as she is
No,
now,
thank
except
you.
she'll be on screen.
She asked me that I wanna come.
Yeah.
Okay.
So
That's fine.
I've written it in person, transport if available, or Zoom. Okay, so we'll figure that out.
I don't want Zoom, Your Honor, I know how to come. I can come.
You won't be able to come here from the inpatient treatment.
Oh, so how am I supposed to do Zoom? I don't know.
Zoom, they have it. They're
At the
used to do
courthouse?
this.
At the courthouse?
They know how to do it.
No, I'm talking about.
The facility, wherever they place you, they're used to doing this by Zoom.
Oh, okay,
So,
okay.
okay,
I've never done it before, so.
I know, that's why we've got that, okay. Okay, any other questions, ma'am?
No.
Okay,
Thank you.
thank you. Oh, you're gonna have to cooperate with probation. They'll contact you, they're a jailer program, and they're going to do a detailed pre-sentence investigation report. I can't do sentencing without it. You'll need some time to go over that with your attorney, okay? Okay, so, any other questions? You've got your go-to person as your attorney, you know how to reach him, right?
Yeah.
Okay, thank you, that's all. Thank you,
Thank
Council.
you, Your Honor.
Thank you, thank you.
That's it for the morning.
Huh?
That's it for the morning.
I don't think we've got one more. Do we have one more?
What is it? I don't know.
We are done the criminal? We're this morning. Okay.
Okay, we just got one more. All right, this is docket 26-4160 AV. Dowry versus Lenise. Lenise Aubrey. Counsel, you're both in for her?
Yes.
All right. Sir, please raise your right hand. You swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and nothing but perjury?
You?
And ma'am, please raise your right hand. You swear to tell the truth, whole truth, and nothing but the truth and nothing but perjury?
I do.
You can put your hand down. And you are Todd, is it Dowry, Dowrick?
Yes,
And ma'am, you are Lenise, Lanese, Aubrey, Aubrey.
Yes.
All right, thank you. This is an appeal. I guess this was done in emergency fashion. You're both here, so you waive the time frame. So it's my understanding that there was a judgment in district court, a money judgment in the amount of, there's a possession judgment, the amount of $2,767.60. But then a money judgment, the amount of $1,879.54. So. Sorry, have you been paid the money that you're owed?
I'm sorry.
Have you been paid the money that you're owed?
No, the judgment was just on, the 14th, the
Okay,
13th, so no.
and is she still in a residence?
Yes, she has.
Ma'am, you've appealed this, you say the money is not owed?
That money is incorrect, the amount that's owed,
What are you claiming is the correct amount?
$1,073,895.
I'm sorry, 1,073?
Oh yeah, 985.
Okay, you just give me three different numbers, so what is it
1,073,985
representing what?
for July and August.
So 1,073 represents what?
The rent for July. Oh, you mean how much is it?
How much do you think you owe him? And what is it representing?
It's for rent, but the judge, he filed this in May.
I don't care, I've got the paperwork, I really don't care, I wanna get to the bottom line of what's the dispute here. It appears that you're living there and haven't paid your rent, so in your estimation, how much money do you owe and what is it for?
When this was filed, it was paid. And then
What was paid, okay.
what you initially filed for. And then I received this in the mail, and I said, is this legal? I already paid him. I paid him on June 15th, and he still went through with it. That was.
I don't care what he went through with, ma'am, I don't mean to be rude, but you know your case and I don't know it, and I
Right.
just got this, so it didn't give me even 24 hours to look at it, so I've taken this, I don't have to, you're both here. So I need when you say it, I don't know what it is, I need to know the dollar amount that you paid and what you think you owe or don't owe, and then I'm gonna have him respond as to why he's requesting this, so can you help me out with that, please?
$2,282 or $86 was paid June 15th. I
And
do,
what is that, $2,286 was paid June 15th, and what does that represent?
that represents May, June, and part of the judgment.
And how much is the rent per month?
July, 1,073. I give help by Section 8. It went down in August to 985. It goes back up September 1st to $1,063.
Okay. Okay, let's just start there. Sir, what is your feeling about the $2,286 that was for May and June?
there was a balance from June, and I have the ledger in front of me, I'm happy to share it with the court. There was a balance from June after Ms. Aubrey made a $2,286 payment. There was still $377 owed, recorded on the ledger. Then the month of July, her rent is $1,450. Section 8, Lansing Housing Commission paid $377. She paid nothing in July. In August, Section 8's portion was $465. Ms. Aubrey paid nothing. So the lease, the ledger was shared with Judge Flores. I had prepared the numbers that I thought were appropriate. He changed the numbers a little bit, a little more than what I had by about $40 for the possession judgment. That's it. So she owes a lot of money. The judgment amount that Judge Flores determined was the $2,767.60. The money judgment prorated to the day of court, $1,879.54. I think those numbers are very close. Again, I had a tiny bit less in my calculations, but these are his calculations. Again, no money paid by Miss Aubrey in July, and no money paid by Miss Aubrey in August. And she had a balance of $377 for June after she made the payment. If the court would like to see the ledger, I have it right here.
Ma'am, have you seen the ledger? Are you disputing this?
Yes, I'm disputing that. The ledger I have only goes from April to, this looks like June of 26. So April of 25 to June of 26, that's all I have. I'm disputing it because I don't owe that much money. And the 377, somehow he must have got it mixed up when the failed inspection went through, and put that on me. But if you notice, 377 is what Section 8 pays, except for in August, they paid the $465. My only dispute is, it was paid, how can this go through? I know you don't want to hear it, but that's just, my only dispute is, how can you do this when I paid you? And I wanted to see where it was gonna go, like if the judge would listen to what I'm saying. You know what I'm saying? It's,
So, sir, I think what she's saying is that in June, the $377 that was owed was Section 8's responsibility. Did they pay it?
Section 8 made a payment of $377 in
June.
June.
Mhm.
At that point, Ms. Aubrey still owed $2,663. She paid $2,286, leaving a balance of $377. So $377 from June, but she didn't make her copay for July or August.
Did you pay July or August, ma'am?
no, I did not, Your Honor.
So,
I owe for July, $1,073. I owe for August, $985. I don't owe for court costs, the $377.
court costs is statutory. That's just what happens. When they bring you to court, you have to pay court costs and there's interest.
But it got, the thing got signed after I had already paid my rent. And he didn't call down to the courts or tell them she paid me. He just let it go through. So I just.
Sir, did she pay you before you went to court?
No, she owes the balance that I stated. The case was filed in May. She has never been current since May. I mean, she's made, Section 8's made payments. She's made some payments. I've been going to court for 35 years as a landlord. The amount owed is the amount owed when you get to court. And this is what she owes. To me, it's very straightforward. Again, I have the ledger if the court would like to look at it.
Okay, and so you have, so this money judgment, the damages of $1,725.19, is that the amount that's owed by your ledger?
That is the amount that was owed as of the court date of August 12th. So that was prorated to August 12th. The possession judgment goes through the end of August. So the money judgment is always a whole lot less.
Right, okay, so, this is gonna go up again in September. She needs to pay $2,767.60 in order to stay there, is that correct?
Yes, $2,767.60 through the end of August.
Right,
Rent's due again September 1st.
okay. So ma'am, what they added on for cost is $154.35, okay? So it appears that you owe $2,613.25 in rent, plus those extra costs that the court adds on by statute.
I don't owe that, and it's that my Section 8 coordinator also said he's got this judgment more than what you pay for rent and what we pay combined. I said something to Todd, he said he didn't know the judge did it. I said, you didn't correct him?
Okay, so what did the judge gave you more?
I had slightly less in my calculations.
Okay,
I had, for the possession amount,
yes,
I had $2,575.
okay,
The judge took the ledger and he came up with $2,613.25 plus the court costs of $154.35 for the total of $2,767.60. I had a little bit less. So with the court cost for the possession, I had $2,729.35.
okay, so that should be the correct amount.
So like $40 difference.
Okay.
And then my money judgment was slightly different by about $40 as well.
Okay, so ma'am, how much money is off?
A lot. I owe $1,073 plus $985. The court cost then. $154.33 is the court cost, if I'm not mistaken.
So,
And when my rent is late, it's not even a question. I pay my late fee. And my late fee went from $50 to one day, he says, no, you owe $70. So I said, I'm not gonna argue with you. I just paid the $70 when my rent is late. No, yes, I'll admit, my rent does be being late. I don't qualify for Medicaid anymore. I have to pay for the Medicaid thing that they have me paying for. So with that and dental and rent, it totals more than what I bring home.
Would the court like to see the ledger, Your Honor?
I will in just a moment. I just
Okay.
wanna figure out the lay of the land here, and then we'll figure this out.
And my receipt doesn't say I owe anything, you just got it paid.
So it looks like what's disputed is $850.
Yes, it's quite a bit disputed. I do owe July and August without question.
Well, do you have the money to pay July and August?
Yes,
Why haven't you paid it?
because I don't know why I have not paid it is because he filed this in May. I was unaware of it. I paid him June 15th. And then I get this thing in the mail, and then I called my son, I said, is this legal? I already paid him. He said, I don't know, God gonna do what he wanna do. So I wanted to get my say in the courthouse and explain what's going on.
Well, what's going on is you remain delinquent in your rent, and so he's frustrated and he brought you to court because he doesn't want to keep doing this paperwork every month. Can you pay your rent on time every month? What's the holdup?
So
I don't care about him. I asked you, why are you not paying your rent on time? And so you like paying late fees?
sometimes I don't have a choice. So I'm gonna admit that I don't have a choice but to pay my late fee. So, because like I said, they have the rent is due after the 5th, it's a $70 late fee. Okay, and then I have the insurance, the health insurance, and then I have the dental insurance, and then I have to pay for my medications, and I have to pay for the doctors. I went from, here you go, to, oh my goodness, I have to pay for everything.
Okay, all right.
And my
Sorry.
check doesn't equal that.
Can you get the ledger for me, please? Have you seen the ledger, ma'am?
I don't even know if this is the correct one. I don't know.
Brought you a copy, thank you, sir. Is that an extra copy for me, or can we make a copy?
I have a copy for her, you, and myself.
Great, thank you, sir. Okay, ma'am, I'm gonna give you a minute to look at the ledger. Tell me where it went wrong.
And here he's got June 377. Who owes that?
Looks like the yellow is what you owe, am I correct?
Okay,
Yeah, she, if I may,
Yeah.
I put an asterisk by that. $263 was due. Ms. Aubrey paid $2,286 in cash on June 15th. That left a balance of $377. That was for the month of June. And she paid nothing in July and August.
So he carried forward the 377. And that looks like the 377 was paid by Section 8. Is that who paid that?
So then, 377 was paid by Section 8 on July 1st for July's rent, leaving a balance of $1,520. And now we're into August. The balance from July of $1,520, the August rent of $1,450, the late fee of $70 for August. There's a total of $3,040. For the month of August, Section 8 paid $465. That leaves $2,575, which is the amount that I had on my judgment form that I prepared for the judge, but he recalculated it and came up with about $40 more.
the judge waived the late fees because of the filing and that I had paid it on June 15th. So he took off the $70 for July, the $70 for August. I don't know where he's coming up with this 377 from, but I do owe $1,073 for July, $985 for August, as it states right here that I'm supposed to pay.
Ma'am, show me in the plaintiff's accounting ledger here where it went wrong. Where,
He's got me paying the housing commission part for some strange reason. This is the second time this has happened with him.
sir, in June, it looks like the 377 was credited to her that was paid from the housing commission, right? Or from Section 8.
The 377 that was owed in June
You
was
have it under the paid
paid by
line.
the Section 8 on July 1st for July's rent, not for June, but for July's rent.
So did they pay any for June? It looks like there's a 377 amount paid.
They also paid, they were paying $377 per month until August when they started paying $465.
Okay, so it's curious to me that she has a balance of 377 when they paid 377 in June.
My answer to that would be, for some reason, Miss Aubrey took away, didn't pay the full 263. I would
Okay.
think if, maybe she was thinking section 8 will pay the 377, but they already paid for June the 377. I don't know why she didn't pay the 2663 and she paid 2283.
So I think the confusion comes in, you had an amount of $3,040. The rent was due, and that was, there must have been some amounts accruing. How much is rent doesn't usually fluctuate like this. What's the rent that's due every month regardless of who pays it?
The rent that's due every month is $1,450. What fluctuates based on the tenant's income with section 8 is their income. So they change. We get letters
Right,
saying the amount that they're responsible for and what section 8 is gonna pay.
okay, so, because it looks like there's been an arrearage, she's owed you, she's never paid the full amount, so there's always been an amount that's carrying forward, that's due, is that right?
Yes, so looking at the ledger, the second page, April of 2025, there was a balance of $109. Miss Aubrey has not been current. I mean, she wasn't current in April of 2025, and hasn't been current ever since all that time.
Right, so, ma'am, that's the problem, that's where this difference in what you're seeing is, if you go through, you have not been current in a year and a half. And so what's happened is the amount keeps growing, you think you're catching up, but you have remained behind, and that's why you're behind at this 800, that's where the $850 difference is.
I'm not a month behind the rent. I'm not $800 behind the rent.
Well, ma'am, can you show me, I have to deal in evidence,
Because
okay?
I'm looking at this right here, and he's the $377, $377, that's what they pay. I pay $1,043, add on late charge when I'm late, and I pay it.
Okay, but,
I tried to pay 50 once, he said, your late charge is 70. I said, when did it change to that? I said, okay, so I paid $11.43 when I'm late, $11.43 when I'm late.
okay, ma'am, but I want you to look at the rent due. If you look at the rent due column, that's how much is owed, and you have never been at a zero balance. I mean, you've been as high as March of 2026, you were $3,751.64. Now it's gone down. In April, it was $728.64, but then it goes to what becomes due is $2,248 because you've never been at a zero. So that's the problem.
But I don't know where he got this from.
Do you have a ledger? Can you show me how much you paid?
Yeah, I run my bank statements, this isn't mine,
What?
this is not mine.
What do you mean?
Somebody named Tanya, they gave me somebody else's bank information.
You mean the bank or the?
The bank did.
Well, we can bring this another day, but here's the thing, ma'am, I need you to go through we can set this out a few weeks, you can go through his statement, but you're gonna have to show me where he went wrong. It looks like on a regular basis, he writes down every single dollar amount. I don't know if, I haven't done all of his math, but you're telling me you owe $850 less. He wants you to move so that he can have somebody who pays their rent on time, or you catch up and pay your rent, or you have to move.
I've been there almost 10 years. Next year would be 9 years. But
Okay, but
when
that
I did
doesn't
my
give you,
calculation, he's charging me full $14.50.
but he does have to charge you the $14.50, and then there's an offset from section 8.
Right, but that's what I got. When I added this up, He's charging me $14.50 the section 8 part and prorated rent part. I don't know, it's $32.83 if you do the day by day for August, but I'm not doing that because I saved $985 and 1,073. And if you add the 154.33, yes, I have that.
Your Honor, if I may, from July, the rent is $14.50. Section 8 paid $377. So that's over $1,000 right there for the month of July. And then for August, the rent is $1,450. Section 8 paid $465. There's another approximately $1,000.
Your Honor, here it is right here. He has the same paper that I have where my rent was changed to $985, where they paid $465, but I don't see it on here. And he also has the one right here where September rent is gonna be $1,060, starting September 1st.
I reviewed this very carefully. So did Judge Flores. I'm not hard up for money. I'm a very successful real estate investor. Been doing it for 35 years. I don't look to cheat anybody of anything. If I had made a mistake, I'd be the first one to admit it. I don't see any mistakes here. And for July and August, there's a couple $1,000s plus the late fees right there. So that's most of it.
The late fees were waived.
Well, I don't know what Judge Flores did, but I mean, he's got some numbers here, and admittedly, he said it's $40 less. So even if we make this $40 less, that would mean you owe $2,727.60. Do you have that money?
I don't owe that. It's right here, what I owe. I put it in the thing.
Please bring me her paper. Okay. Sir, do you have a copy of these?
No,
Well, let's make the facts. Ma'am, that's what you owe. That's really not the question. The question is, how does the landlord get his full payment every month for the $1,450? And you've never been current to make a zero balance, at least not in the last year and a half. So it's been
But I
carried
have.
forward. You can say you have. Do you have proof that you have paid and that his numbers are wrong? I have to deal in evidence, man. I would love to say live there forever, but I can't do that.
They gave me somebody else's stuff from the bank.
Well, then we can continue this, but man, you're gonna have to go through this along with your bank statement and show that somehow his numbers are wrong. Otherwise, this has to stand.
So you said you can do what to where we come back and I show you?
Well, if the bank gave you the wrong statement, you can go through the ledger he just gave us, compare it with your right bank statement, and then get with him and show him where it's wrong, or show me and him in court what's wrong. But he's got this day to day, he regularly keeps this, I suspect he does this with all the tenants, and he's got it listed here. You have not shown me a mistake he's made. You just keep saying that it's $850 too much, but I don't see where the mistake is, and you don't have any evidence of an error.
Your Honor, the payments made by Miss Aubrey are always in cash. There's no bank statement that would show she's not getting a money order, she's not paying a check. As I look at her ledger, she is paying in cash, and then Section 8 makes their payment electronically.
So ma'am, how are you gonna show me what you paid?
Because I draw it out the bank when I get my check. See, my checks don't be coming on like that. Sometimes when I get them before it's due, I give it to them. But when it's past that date, I give them the 11/43. I did get, just started learning how to use this daily pay stuff, but I do owe, because the judge waived the late fees, I have to pay the court costs. He agreed with me being right about what I said, and it should be 1,073 plus 985 plus 154.33, the court costs. If I'm not mistaken, that's what the court costs are. So the 377,
Ma'am, you'd have to go back to that part and tell him he made a mistake, because I don't have anywhere here. I have a judgment signed and entered by the court. And I don't have, what?
I have to go back to that court?
Well, I don't know if he made a mistake.
I know he made a mistake, because he's saying, he's adding this stuff together, and that's not what it's supposed to be. Because they pay their part, I pay my part.
Ma'am, here's the problem. I wasn't there, and the only thing that speaks to me is the order of the court. And the order of the court says that there's a money judgment in the amount of $1,879.54, and a possession judgment of $2,767.60. And to the plaintiff's credit, he said it was $40 too much, so I suspect he would accept in satisfaction $2,727.60. And then you can stay there. You need to show me a mistake.
You said 2,000.
$2,727.
I don't know that, Your Honor, I don't. I owe 1,073,985. If you look at what he says, if I move out, the
money judgment,
$1,879, if you do the prorate on that, you will see that that's like 1,400, it's not correct. It's not adding up correctly.
well, according to, he agrees the judge did $40 too much, so I imagine on this, and he can tell me, it'd be $1,829, or no, $39.54.
For 35, excuse me. That's 35.
I have a copy of my calculations, if the court wants to see that, they're exact. Would you
Okay,
like to see that?
sure.
I'll explain it.
Is that from the court?
This is what I wrote up. Sometimes the judge, I'll hand this to a judge and they will sign it and it'll be done. But in this case, Judge Flores calculated the numbers slightly different than mine. I made the notes on this sheet and then we submitted with M-File what he's told us to do. So the amounts that I came up with, the possession amount, rent, $2,575. Court costs, $154.35, for a total of $2,729.35. That's what I believe is correct.
Okay,
Then for the money judgment, I had $1,686.29 plus the court cost of $154.35 for a total of $1,879.54.
so ma'am, you need to pay the $1,879.54 if you want to stay there. I haven't sent any evidence that you've already paid some or all of that.
You know what, Your Honor?
And then you've got the rent from September coming right at your door.
I just wasted everybody's time,
Why?
because I thought I was supposed to pay this up here. Almost $3,000. That's what I was focused on. I didn't know what this part was for. I thought this part was for if I move out.
So you have money to give him?
Yes, I do. Yes, I do. I didn't. That's what I was disputing.
No,
I think maybe she is misunderstanding something.
Yeah, I did.
Right.
The
That's-
possession amount
right, possession
is
is
the
different.
2,767.
That's what I thought I had to pay this day.
The what you owe, if you would have moved out on August 12th, was the 1879.54. That doesn't get you to the end of August. The
No, it's-
possession amount gets you to the end of August.
1,000. Hold on, let me do it. 1,073 plus, I didn't break it up, 985 plus 154.35. $2,212.35.
That math still doesn't jive with this math. I don't know where you're going wrong, but. is
Well,
it
that's
your-
for the whole month of August, the whole month of July, and the court costs, because the late charges were waived.
But she's forgetting the 377 still.
But I don't
from
owe
June.
377.
Well,
And my coordinator even said, but I don't, he's charging me their part, and he's not supposed to be.
well, let me
It
look
says
at
it in the email, if you wanna read it.
What, sir, under June, it says amount paid 377, and then you also have a balance of 377.
Yes, so section 8 paid, and the balance from June at that point was 3,040.
Yeah.
Section 8 paid 377.
Yeah.
That leaves 2,663. Then Miss Aubrey paid $2,286, which left 377.
Yeah, a curious amount, but still. You see that, Dan?
If, where he's saying 377?
So where there's the asterisk, under June, there's June, then there's a blank, and then there's an asterisk. And if you go 2 lines over, the rent that was due at that time was $2,663. You did pay $2,286. Miraculously, it's what the balance is due is the 377. That's the same number that section 8 pays, but he did give you credit right above that kitty corner for the 377.
If he gives me credit for theirs, it shouldn't be no 377.
You had a balance of 2,663. You paid 2,286. If you do the math, it's 377 balance that's due.
Mine is, $2,286 when you add May and June together with the $70 late charge, which is $1,143. That's exactly what I paid because that's what I owe. Now come July, then I get the court papers, and I just wanted the judge to hear why I haven't paid July and August.
Okay, but you had owed 3,040. They paid, section 8 paid 377. It left you with a balance of 2,663. You paid 2,286. You were short 377.
Somewhere up here, he didn't subtract something, he didn't subtract their 377, because I'm responsible for $1,043. And when my rent is late, it's $1,143.
And he's
that's
got
what I
it
paid.
marked under amount paid. Every single month, he's marked 377, every single month. The problem is, Ben, that you have never been at a zero balance under rent due. So what's happened is your rent is greater than 1,450 because you're always carrying forward a balance of unpaid monies.
That's not my unpaid money, though. I don't know where he's coming up with that from.
Well, ma'am, April,
He's writing this down, but it makes no sense if you look at it, 377 on the Lansing Housing Commission part, they're 377. And then the for
ma'am,
465. I don't dispute the part that I owe, but that's why I corrected him in the text message. You know, you mean $2,286, and that's what I paid him. And he never said, no, you don't, you gotta pay more than that. It's not on my receipt. I think somewhere up in here, he's forgot to subtract their amount and he's putting it on me.
Well, here's what I'm gonna do. I'm gonna let this judgment stand. You can refile a motion for me to reconsider. You have to go through his ledger and find a mistake. And I want you to look at what he's done. So if we go back to April of 2025, you had a balance due of $109. May, you had a balance due of $1,094. And then it does show what you've paid, but then we go to June and you've got 1,070. Is that no, you've got $107 that's due. And then it goes to,
What is it for?
because you've never paid, you've never gone down to zero.
Yes, I
Where here, there's not 1 month in a year and a half where you have zero rent due. Where
I
you're
have.
totally caught up.
have.
Then you, ma'am, I would love to believe you. I really would, but I deal in evidence. He's given me this evidence. I need you to give me the other evidence so I can make a decision. Otherwise, this has to stand.
Well,
So I need you to go through this ledger and find out if there's a math error or if it doesn't coincide with your cash disbursements. And then we have something to talk about. Otherwise, this has to stand. I suppose minus the $40 that you both agree he doesn't owe, or you don't owe him.
I don't owe the late charges.
Again, I don't know what the other judge did in regard to those.
He knows that's true. He was saying it right there when he said it. And then even my worker said, this doesn't make any sense. This is more than you pay in rent. Why is this so high?
Because you've never gone down to zero. Am I correct in that? According to your ledger, I've never seen a zero.
That's right. That's
I
correct.
have. Like I said, Todd has made this mistake before. He corrected it. And when my rent is late, I'll pay my late charges.
Okay, ma'am, he's been honest to me about the $40. I
I
don't
don't
think,
know.
wait, ma'am, I think if you show him an error, he's gonna fix it. But I don't see an error in this, and I can't rule on what you say. I have to deal in evidence. You don't have the evidence, so I'm happy to relook at this, but this is going to stand until you bring to this court some evidence of an error. So you need to look at those bank statements and tell the bank they gave you the wrong numbers, and then match up what your cash withdrawals are that you gave him with this and see if there's a math error.
Okay, and I have to go, okay.
Because I just can't say, oh, magically you win because your argument's good. It doesn't work that way. I need evidence, okay?
Right. And then back, I can get it. He's just gonna put me out. So I'm trying not to get put out. I know what I owe. So they said that they'll stop the red. So I'm gonna have to move because I don't wanna be put out in the streets.
Right, and so, I mean, the other thing to do is to pay it to a zero balance and then stay, and during the month you stay, come back.
It's been
and show
there.
me
I
money.
know you don't.
It's not that I don't believe you, ma'am. I deal with a lot of this, and I was a district court judge, and I get all of this. I just cannot rule without evidence.
I wish that this, I wish I had.
But you can come back and show me, you can show him he's a reasonable person. Okay, and otherwise you're gonna have to move.
Yeah, I'm gonna have to, yeah.
Or make good on your rent and stay, and then maybe you can get a refund if we find the error, okay?
Well, I'm pretty sure he won't do that, because when I was overpaying my rent before, he never credited it.
Again, I don't see any overpayment that may have occurred
It's
years
happened.
before, but I'm not disputing it has. I have to deal in evidence, something tangible. So bring me the tangible money or dollars, and we'll have something more to talk about.
So in order to stay there, I have to give him $2,700 and something.
You have to give him $2,729.35.
I'll get what I need to get, or I'll just move out. And the thing, because he reported this to he reported it to my worker as well and got in trouble for that because he wasn't following the procedure.
Okay.
Do I need to resubmit something to this court?
If you want to resubmit with the $40 less, that's fine. Otherwise, it can just stand as is. I don't know.
Okay, I'll just leave it as it is then. I'll just know it's $40 left.
Okay,
Thank you very much.
thank you.
So I have to file a what when I find a mistake?
Well, you can come back here and file, you can ask me to reconsider this because now you have the evidence. With the state, I don't know what you have to file.
Oh, I just come back to you and show you?
You would have to set another hearing and we would go through this and I would have to look at the evidence, okay? But you'll have to find an error and show where his math is wrong, okay?
Okay, will do.
Thank you very much.
Thank you.
Thank you. The order stands at this point. Thank you very much.
Is it okay that
Yep, we're done. Thank you.
am I gonna like get a copy of something saying like it stands?
Did you just get one of those blank orders?
Oh, I feel it. I got it.
Let me just do the blank order here. Do the caption.
Nobody would answer their phone. Basic stuff I have a piece of 2x4 broke, so I can't get nothing out the base.
Kennedy, can I have that file, please? Look at that in the package, please.
Thank you.
Thank you. Good luck.
Thank you.
It's all for the record.
Focus on possession, but on stay.
Here's that.
The three.